Right, good afternoon to you. Welcome to Good Afternoon Ghana. It's a Friday, the 13th of August, 2023. We're doing the final edition of the program before we go into the weekend. And that has to do with what was what hit us yesterday from the courts. That's Accra High Court. So remember that the government of Ghana in 2017 undertook a banking sector cleanup under the supervision of the Finance Minister Ken Ofori-Atta, which saw the reduction in the number of, some 34 banks to 23, whilst 347 microfinance institutions, also 15 savings and loans, 8 finance houses and their licenses revoked. Now, from this one, a number of the institutions that had their licenses revoked were to have varying degrees of corporate governance lapses. So the total estimated cost of the state's fiscal intervention, including interest payments from 2017 to 2019, was pegged at 16.4 billion Ghana cedis. The exercise, should I say, has received its extended purpose, where we have seen the amalgamation of banks, right, into Consolidated Bank of Ghana, and latest, the conviction of a former CEO of Capital Bank, Mr. ATO ESSIEN. Going in for 15 years, it's indeed an issue for us to prove. We've been proving for yesterday, and today we're continuing. And we'll have our guest with us via Zoom is ALFRED TUAH-YEBOAH, who is a Deputy Attorney General, to join us and explain some more to us what exactly is happening in the court. Well, it has to do with various banks, right? Not just Capital Bank, but the latest has to do with ATO ESSIEN, who is now going in for 15 years. What does it all mean to us? We'll go for a breather. We'll be back shortly. You're welcome back. You're still on Good Afternoon Ghana, and I remind you that this afternoon we're turning the lenses onto what happened yesterday in the courts. That's Accra High Court sentencing ATO ESSIEN, who is the founder of Capital Bank, to 15 years imprisonment. This follows the banking sector cleanup that saw a couple of banks, some savings and loans and financial institutions having their licenses revoked. The lawyers have been speaking following this matter. But this afternoon, we're engaging with the Deputy Attorney General, for Ghana, ALFRED TUAH-YEBOAH, to tell us more. He's been leading this case on behalf of government, and I think he's joined us via Zoom. Good afternoon, lawyer. Thank you so much for your time. You're welcome to Good Afternoon Ghana. Rather unfortunate for the last minute changes.
Good afternoon, my sister. Yes.
Right.
I think I ought to have been in the studio, but circumstances changed. I had to join via Zoom.
Right. Maybe another time we can have you with us. So quickly, let's just go into everything that has happened. Take us through the journey of what government's role has been with identifying what happened with these banks and government's decision to revoke licenses, and where we are today with our former founder of Capital Bank being sentenced to 15 years. Take us just through, summarize the journey for us.
Thank you very much, my sister. Yes, as you already indicated in your intro, somewhere in 2017, there was a decision by the Bank of Ghana, after having gone through the books of some of the banking institutions, as well as savings and loans and microfinances, to revoke their operations because of various breaches. And after the revocation of the licenses, extensive investigations were conducted into the activities of the various institutions, one of them being Capital Bank. Now, in the case of Capital Bank, when they were distressed somewhere in 2015, 2016, the government, in its wisdom, in order to give them that kind of liquidity support, advanced to them an amount of 620 million Ghana cedis, as I said, as liquidity support. The brain behind it was for them to use that one to shore up their capital so that they could just run effectively in the country. When that money was received, they used part of that money to support the liquidity position of the bank. But investigation further revealed that not all the money went into the bank. And because of that investigation, the security agencies, more particularly the YOCO and the police, they also stepped in. After investigations, it came out that an amount of close to 250 million cedis wasn't invested in the bank's activities as they were supposed to do in accordance with the monies advanced to them. Further investigations revealed that the then CEO, ATO ESSIEN, had used part of that money not relating to the business of the bank, but he had used part of the money to invest in other related companies. So when we realized that those monies were in those companies, they were blocked. And so in summary, at the end of the day, realized that an amount close to 90 million plus had nothing to do with the activities of Capital Bank, meaning that money went into the private pocket of some individuals. Some individuals were questioned, arrested, and cautioned. At the end of the day, some of them were put before the law court on various counts. Mr. ATO ESSIEN was one of the accused persons. The state then decided to commence prosecution. In the course of the prosecution, after we had gone through extensively, Mr. ATO ESSIEN, through his lawyers, made an approach to the Attorney General for us to look at Section 35 of the Courts Act, which talks about situations where there is the prosecution of an accused person involving a matter which has led to a financial loss to the state.
Yeah.
And so in that negotiation, they made various offers. In fact, it started way back, I think somewhere even before 2021, somewhere 2021. But we kept prosecuting the matter while we were doing that kind of negotiations. Last year, December, we were able to reach an amicable arrangement where the state accepted that Mr. ATO ESSIEN will be paying 90 million Ghana cedis, made up of an amount that we claim he had stolen, together with restitution and reparation. In that agreement, in line with Section 35.
Just a moment. So, out of 250 million that we saw that it went into activities that were not related to the banking activities, out of which 90 million is what ATO ESSIEN was supposed to pay.
That's the case.
Right.
But even with that 90 million, initially he said he was liable to pay about 27 million Ghana cedis. We rejected that offer. Then later, he also conceded and said the amount was close to 57. That one too, we raised an issue. But we said even if we're going to accept what he had offered, then he must make further payment as restitution and reparation. So the net effect is that the 90 million constitutes the amount that he admitted, together with some form of reparation or restitution to the state. Because if you look at Section 35, if you want to take advantage of it, the amount that you admit that you have caused a loss to the state, apart from refunding it, you are also supposed to make reparation. or restitution to the state. So the 90 million includes restitution and reparation. In that agreement, we insisted that he should pay 30 million of the 90 million before we even go to court. True to his word, on the very day, a day before we went to court in December, he made a payment of 30 million Ghana cedis, remaining 60 million. And we agreed that the remaining 60 million will give him 12 months to liquidate that sum. And he was liquidate that sum in 3 equal installments. The first installment, he was supposed to have paid 20 million Ghana cedis by the end of April 2023. The second installment, another 20 million Ghana cedis by the end of August 2023. Then the last installment, 20 million in December this year. When the first installment became payable, Mr. ATO ESSIEN paid only 5 million Ghana cedis. And so, based on the agreement that we had, we filed an application before the court that having failed to pay the 20 million as we agreed, then the entire amount became payable and that he was supposed to pay that amount. And failure to pay, the court should proceed to pass custodial sentence on him. This application was served on him and we went to court in May, early part of May. When we went, his lawyers pleaded to the court that at least they wanted some time to pay. We took an adjournment. When we went to court on the adjourned date, we realized that he had paid 2 million Ghana cedis, making it 7 million, which was just far below the 20 million that he was supposed to have paid. The matter was once again adjourned to end of July because the court said the court was giving him the last opportunity, a lifeline, so that he could just liquidate the amount that he had agreed to pay. At the end of July, when we went to court, fortunately for him, the court did not sit, and there was a legal vacation. And for that matter, the case was adjourned to yesterday, that's October, almost 2 months plus. So we were thinking that he could use that 2-month period to make payments. However, we checked from the accountant general whether he had made any further payment. I realized that as at Monday and Tuesday, he had not made any further payment, meaning out of the 90 million, he had been able to pay only 37
million.
So we went to court yesterday and told the court that we are ready to move our application requesting that he should be sentenced into prison custody. So the application was moved and the court at the end of the day acceded to our request and then sentenced him to the various prison terms. And because they are to run concurrently, he is supposed to serve 15 years imprisonment in hard labor. So that's where we are.
So just so viewers are clear with the acts that we're reading, so Section 35 of the Courts Act, do we pick one or two, or we can read the two together? So let me read from one. It says, as whereas a person is charged with an offense before the court or a regional tribunal, the commission of which has accused the economic loss, harm, or damage to the state or the state agency, the accused may inform the prosecutor whether accused admits the offense and is willing to offer compensation or make restitution and reparation for the loss, harm, or damage caused. And then 2 says that where an accused makes an offer of compensation or restitution and reparation, the prosecutor shall consider if the offer is acceptable to the prosecution. Just so viewers are a bit clear of what we're referring to, that's the Act 35, Section 35 of the Court Act. Now, let me just find out if the plea bargain which was obtained was flexible enough. Do you think that it was flexible enough? And what do you consider, what does the court consider as flexible?
All right, thank you very much. Now, if you read the Section 35, even if the prosecution and the accused person agree, it is subject to the approval of the court. And so in our initial agreement, we said 12 months. In fact, when we went to court, the court even queried why we're giving 12 months, and the court was even mindful to even reduce it to 6 months for him to liquidate it. But we insisted that the court should oblige him because we didn't want a situation whereby we want to force something on him. If he's not able to get it done, then he may say, because you forced it on me. So the court said, fine, I'm giving you 12 months. So we were so clear in our minds that Mr. ATO ESSIEN was going to go by the terms of the agreement because he, on his own volition, agreed to the terms. We never imposed the terms on him. And then we were expecting
But he once pleaded that in a situation where he defaults, he should not be jailed because he has defaulted. And you in particular opposed to it. Why so?
I oppose that request because if you read the section 35, even the court does not have the discretion to extend time for an accused person who has defaulted. Because the operative word there is shall. The court shall proceed to pass custodial sentence when the accused person breaches his side of the agreement. So I made that point in court that even the court doesn't have that power. But I just want to stand. The court said, oh, let's give him some time. That's why from May, we waited until yesterday. Otherwise, the application that we filed in May should have been moved in May for him to face custodial sentence. But the court decided to give him that space.
So I've heard you on other interviews say that you're going to proceed and chase others that, were also mentioned in this whole, happening to the bank. How is this going to happen? If you can tell us what is next for these people.
Yes, currently there are some cases pending in the High Court where some of these bank officials and owners are being prosecuted. So that's the first point. The second point is that those who have not yet been hauled before the law courts, a lot of them have gone through IOCO investigations. And IOCO has prepared various dockets on them. Some of these dockets have been reviewed by our ALFRED. And very soon, others may also join the prosecution in court.
This is regards the Capital Bank or other banks?
Other banks. For Capital Bank, we are not done with Capital Bank. But we have other banks that are also facing prosecution in court as we speak.
Oh, you are done with...
They have also been in court.
We're done with Capital Bank now?
We are done in terms of the prosecution. The only thing left is perhaps the money, recovery of the 53 million outstanding. That's another matter. Because Capital Bank, those that we investigated and prosecuted, 2 of them or 3 of them were acquitted and discharged. It was only ATO ESSIEN who was convicted. So what is left with Capital Bank is about the money that we think he should be paying. Apart from that one, there are other banks, as I said, that are also in court facing prosecution. And there's a third group that have been investigated by IOCO, and the docket submitted to our office for our review, which we have done religiously. And that very soon they also join the prosecution that we are doing in court. And those that are likely to join this prosecution are the savings and loans, as well as the microfinance companies. Because if you operated a savings and loan company in Ghana, you took people's deposits. And because of your actions and inactions, those people nearly lost their deposit. But for the government's intervention, it will mean that the government has spent money on your behalf.
Yeah, I'm going to come there. I'm going to come to the point where government spends money to save, customers. But with the background of ATO ESSIEN and the Capital Bank, we had names like Fitzgerald Odonko, we had Tete Nete, a former managing director, and also MC Management Service owed by ESSIEN and all that. They were charged with 23 counts and all that. That's in the courts. Why do you say that we're done with the prosecution of Capital Bank when others were mentioned? And also, there's been people asking questions that why is it that if the founder of the bank is facing this, we have the board of directors who were also directly or indirectly in charge of transactions of how monies were moved around. How can you explain that legally to us?
All right. Now, the other three that you mentioned, they were dealt with by the courts. They went through the prosecution, and then the courts, after listening to us and listening to their side, acquitted and discharged them.
Wow.
So those other three that you mentioned, they are exonerated because the court has said so. Now, in terms of the board, if you are charged with stealing the company's property or money, like Capital Bank, perhaps your only defense that you can put up is that whatever I did was sanctioned by the board, because the board is the speaking mind of the company. In this particular instance, per the evidence that that was unraveled in the court, the board was not aware, never authorized it, never consented to it. So that's how come ATO ESSIEN was found guilty, or he later pleaded guilty.
That's to say that with all these decisions, financial decisions of moving money about, as far as the banking business is concerned, the board knew nothing about it. Is that what you're saying?
That is the evidence that we had on the docket that we received and then prosecuted. In any event, if the board had consented to the transactions that ATO ESSIEN did, could have called the board to come and testify for him that yes, this gentleman, whatever that he did it on our behalf. We consented to receive. That would be a valid defense. So far as the court has closed that chapter, we are off that area. We are now dealing with only ATO ESSIEN. But earlier I said it's closed. In terms of criminal matters, if tomorrow there's another evidence pointing to the fact that another person within the same setup has done something untoward, nothing stops the state from pursuing that person.
So, the money that we have left with ATO, which he's not been able to pay based on that having been jailed, what will happen to it? Because he's not being punished
remaining
for wrongdoing.
Remaining 53 million Ghana cedis.
Right. What's going to
That
happen
money
to that?
belongs to the people of Ghana. It's the money that we need to recover.
How?
And every step that we need to take to recover, we may have to do that if we can identify an unincumbent property of Mr. ATO ESSIEN. We can go after that property through the legal process to get the money back.
Do we have some of his assets available to government that we intend to liquidate?
During the prosecution, some of his assets were frozen.
Yeah.
But when we reached this agreement with him, he needed to raise money to pay. So I remember that part of the assets were defrozen so that he could sell and then pay. Maybe that's the reason I was able to pay the 37 million. We also later got to know that there was this judgment against him and, for that matter, the company, and that the judgment creditor in that case had also taken legal steps to auction those property. As to whether that thing is the true state of affairs or not is something that I don't have much information about. But the whole thing is that if at the end of the day, we realize that it is something that we also need to check on, we will definitely check on.
So, I mean, finally on Capital Bank, everything is done. What we're left with is a 53 million that's to be recovered by government, considering some of the assets available, how we can auction or liquidate them for Ghanaians to have their monies back. That's the only activity that government must undertake.
That is the outstanding thing to be done at the moment, unless something different comes up later.
So what if he doesn't have any assets that, will amount, after liquidation, will amount to the 53 million? What will be the next move? Because, of course,
That it means there's a loss to the state. That ends it. It means that it's a loss to the state. And let me add this. Last year, when we took this decision to have the Section 35 deal, a lot of people didn't agree with us. People thought that we should have just allowed the court to jail him straight away, or to have pronounced judgment on him. Now, with this new development, we can see the utility in the decision that we took. That if nothing at all, the state has been able to recover 37 million Ghana cedis from one accused person, which has never happened in our history since independence, where the state, through a criminal prosecution, has been able to recover such an amount of money. So actually, even if we lose what is outstanding, we've not lost everything. But as I said, we pursue it to the last letter.
So Ghanaians must take his jailing as compensation to the monies we've lost.
We will not say compensation, but the law says that if you steal our money and you are found guilty, you must be jailed. You can be jailed, and apart from being jailed, you may also lose your property. If, for example, we take a step and then we auction any of your property.
So let me quote this for you. Moving from Capital Bank, we may come back to it, but I cannot, to this day, understand why a 4 billion Ghana cedi problem was made to cost the taxpayer 25 billion cedis. These banks were asked to capitalize to 400 million Ghana cedis. And if there were even 10 of them, that would be 4 billion Ghana cedis. And yet, with the closure of banks, we incurred a public debt of 25 billion guaranteeing depositors' accounts. That's a quote from Mahama on the banking cleanup. We're still yet dealing with other banks who are still, in the coolest, waiting for prosecution. How do you respond to this?
Yes, I think rather this question should be answered by the Bank of Ghana, because they deal with the finances and they can justify why those licenses had to be revoked. But to put it from my layman's point of view, I'm not an economist, a finance person, or someone with banking experience. But what I know is that if one bank collapses, if care is not taken, the entire banking sector will also collapse. Because people will then begin to panic and move around and then get their money from the bank. If, for example, I only mention the name of any bank, there's a panic withdrawal and even 20% of the customers besiege a bank for their money. I tell you, they may not get the money. But that's not how banking is run. So maybe BOG in their wisdom assess everything and realize that pumping money back may not help. I'm thinking aloud. Look at the 620 million that was given. I think the government then, out of good conscience, the Bank of Ghana decided to give that money. But still, look at what happened to this particular bank. So as a state, then do we need to continue still pushing money into it? And even if one of them is not able to sustain the kind of pressure and collapses, the whole banking sector may collapse. I said I'm not a banker. I'm a lawyer. I'm a prosecutor. But those who can speak to this issue as to whether the decision was proper or improper, I think BOG should be able to do it. But I just give you my lay.
Right, but even respectfully, in the courts, lawyers and judges sometimes look at the common sense of activities and events happening around us, and their judgment sometimes is based on how common sense is telling us not so.
It is true, but when it comes to finances, if you sometimes want to use common sense, you may not arrive at the right decision. As I said, it deals with people's perception and the effect that one entity may have over the entire system. For example, you know rural banks in Ghana. If one rural bank collapses, I can assure you the over 100 rural banks may also likely go down. Not because they don't have the money, but because of panic withdrawal. So I know that those in banking will always make sure that they are able to sustain this kind of panic situation. Maybe the Bank of Ghana assessed it. As I said, I was not part of that decision. I'm not a banker. I'm not a finance person. But if they are to be interviewed, they will to justify why they think such a decision was taken.
So which are the banks that are next? We had the 5 collapsed banks include Unibank. We had Unibank Ghana Limited, Royal Bank Limited, Beige Bank, Sovereign Bank, Capital Bank, and all. Which is next? UT Bank, we know it's been a bit controversial. GM Bank also has been a bit controversial. And GM Bank workers, for example, and the I think directors have been asking a lot of questions. Where do we stand with GM Bank? Let's deal with GM Bank first.
Yes, GN Bank, I can confirm to you that Yoko has conducted their own investigations and the Attorney General's office is also studying what they have uncovered. They are not in court. If you take the other banking institutes like Beige Capital of the Beige Bank, the owner of that bank,
I was not too clear with GN Bank. You said the IOCO had investigated, right?
They've done some work on it.
But a couple of times, GM Bank officials or lawyers appeared in court. State prosecutors did not show up.
No. Now, GN issue maybe 2 or 3 different. There's a civil part and a criminal side.
Okay.
I know that they have gone to court to challenge the revocation of their license.
License, right.
Yes, that's a civil side. As I said, in terms of criminal prosecution, nothing has started yet. But they are in court legitimately so to challenge the revocation of their license. But those ones that we are prosecuting or we have processed, you can talk about Beige Bank. You can talk about UT Bank. You can talk about Unibank. The others too are in the works. And those in the works, they are not only banks, savings and loans are also part of the system, as well as microfinance companies.
So give me insight on UT Bank. What also can you tell us? Is the Yoko working on that too? What's the state now?
No, UT Bank, now the matter is before a court of law. Some people are being prosecuted. So I don't want to go into that because they are in court now facing prosecution. Beige Bank is also, the CEO is also in court being prosecuted. Unibank, some officers from that bank are also in court being prosecuted. So I want to rest it there because the matter is before the court of law.
So do you think that your ALFRED will actually challenge an appeal by any embattled member that is involved in this whole mess? Should they file for appeal, for example, if ATO ESSIEN decides to file for appeal, what's going to happen? Are you going to oppose it?
ATO ESSIEN, who is now a convict, has the legal right to mount a challenge of his sentence through the appellate process. He has the right to do so. If he does so, you also meet him squarely in court.
Oh, if he does so, you meet him in court?
Exactly.
Are you aware the sentence really shocked people, that the years were too many?
The judge had the discretion to sentence him up to 25 years. The judge, in his wisdom, decided to spare him the 10 years and he gave him 15 out of the 25. If he's aggrieved or if he's dissatisfied with it, as I said, he can challenge it at the Court of Appeal. But if he challenges the sentence, we'll meet him at the Court of Appeal.
If he's in court, I don't know if that's possible. If he's in jail and he's able to make moves for some of these payments to be made, is there a possibility of the sentence being reduced even though he's trying to work it out as he's in jail? Is it possible? Is it legally allowed?
It is allowed if, for instance, he is able to refund the outstanding sum and his lawyers file an appeal at the Court of Appeal. That one is not automatic, but the judges may weigh all the circumstances and say, because you have refunded, we may want to reduce your sentence or we want to do something for you so that you can go home early. But if he pays it automatically, doesn't mean that he's getting out of prison. It should take the courts to do so.
I see. So ATO ESSIEN still has some hope.
He has some hope, but it's not something that say if you pay it, the court can also say, despite the fact that he's paid, still be in prison and then serve the 15-year jail term.
I'm wrapping up with you, but let me ask you, how far with the case with Kesi Alato forcing as well? What's going on in court as far as the investigation? I know you tell me he's in court, but give me some updates.
Oh, yes. The matter is in court. The state closed this case. Then Mr. Kesi Alato forcing also has called some of his witnesses out of 10. And I think on the next date, which I don't have it now, because they were in court yesterday or something, you call the next witness and then the case will then proceed from there.
So the state has closed its case on that?
Long ago, yes. The court made a determination that there's a prima facie case against him, so he has a case to answer. So he's now answering, mounting his defense.
What was the last evidence provided by the state before the case closed?
Yes, I think Mr. Kesi Alato forcing called one of his witnesses, if I'm not mistaken, Mr. Mode. I think he came to testify for him. And thereafter, I think he has called about 2 weeks, but I stand to be corrected. But on the next agenda, he's supposed to either testify himself or call his next witness.
Okay. So that's where we are with the Kesi Alato forcing case. Now, just before you go, I'll let you go. So all these cases that we're running, are they supposed, because we're using the legal procedures, are they like a form of punishment to send a message across to people that once you have breached the law, no matter who is in charge, you will actually go through these processes and face the same type of punishment?
Exactly the case. We are a nation of laws. We must all obey the laws of the land. If you decide intentionally to breach the laws of the land, the same laws will deal with you. So those who are involved in this banking sector business, they must know that if they never did anything untoward, the court will acquit and discharge them, just like how the other 3 persons were acquitted and discharged in ATO ESSIEN's case. But if you did something wrongful, the same courts will say that you are guilty and will deal with you. So that at least those out there will learn a lesson out of it. Because if you are managing your own company, you may be the 100% shareholder. You should have in mind that there's a legal personality of the company separate from you. And so if you are taking a property of any company, make sure that you have the consent of the board. Otherwise, you've stolen the property of that particular company that you are even 100% shareholder. People don't actually realize that one. And so if you're going to take a loan from the bank, a government bank, or from the government, and you are running your business, which is a company, you were given this money to invest in agric as a company. You take this money and then you use it for funerals or to do things that are not related to the company. Effectively, you have stolen the money of that particular company, and you can be dealt with in accordance with law.
So this is a form of deterrent.
Exactly.
Have you heard responses? Maybe I can throw in one political question. Responses from the opposition party that, well, same law that's been applied on these persons who have mismanaged banks and therefore are going through these legal procedures will be applied to the governor of the Bank of Ghana as well.
I will not have any problem if there's evidence against any person who is in charge of our resources, who has done something untoward and must go through the full rigors of the law. Why not? It's about evidence. If you have that evidence that can stand the test of time in court, and you want to activate prosecution process, I will not stand in your way. But if you don't have the evidence and you go to court, definitely the results will show.
In your earlier response, you actually used the word intentional. If it can be established in court that your action was intentional and caused financial loss to the state or stealing, then you would have to face the consequences. How do you determine the intentional behavior of people in court?
It's very simple. Now, in terms of criminal prosecution, there are two main elements of a crime. You have the mens rea and the actus reus. That's the actual action and then the mind behind that action. The evidence that will be adduced will show or will demonstrate whether you had the intention to commit that crime. And that is the business of the judge. That's why judges are trained to go through this process to distill the evidence in order to arrive at a firm conclusion.
ALFRED Tuah-YEBOAH, I'm grateful for your time this afternoon. And I think the next time we will make time with you here in the studio. We'll be glad to have you here. Thank you for speaking to us.
I'm grateful to you, my sister.
Right.
Have a nice day.
Have a nice day too. That's the Deputy Attorney General, ALFRED Tuah-YEBOAH. You're still watching Good Afternoon Ghana. Let me take a break. I'll be back shortly. So if you remember, ATO ESSIEN had some opportunity to spend with Paul Adumotre here on Metro TV. We have some excerpts of that interview. Let's have that.
I mean, I was the father of microfinance in this country.
So it was like Susu.
It was like Susu kind of a thing, but at the time, we were not even taking people's money. We were rather giving people money.
How did they give it to you back?
They were giving, okay, so
The payback.
The payback, we did what we call joint and several guarantee. So when you come, peer pressure, we put you in a group of 12, and then we give
What
you
is
the money.
peer pressure?
Peer pressure means that you are in a group of 12. 10 people have paid their loan, 2 people have not paid. And if you don't pay, they don't get money for the second cycle.
Or you called it peer pressure?
Yeah, so you will bring pressure on them.
That's interesting.
They will bring pressure on you to pay so that they can get the second capital, third capital, and that sort of a thing. You know, so I was the father of microfinance in this country, and so it went so well. I mean, many times the Bank of Ghana, in most of their presentation, will make reference to ATO ESSIEN.
Oh, I see.
It wasn't regulated, no.
Oh, I see.
No, yes. Yes, so I was using the money lender's license from the Ghana Police Service.
Ghana Police Service?
Yeah, Ghana Police Service. That was the license I was using.
Oh, that's
at
how
that
you
time.
get the license in those days. Which
Those
year
days.
was this?
This was 2004.
Ghana Police Service?
Yeah, Ghana Police Service.
That's how you got your license
Yes.
for regulation?
Money lender's license. That was how it was, you know. And it was a beautiful journey because by 2006, Paul, we had taken care of almost about 4,800 market women. First Capital Plus, the idea behind it was a fantastic idea, driven by technology, driven by ingenuity, creativity. So what we sought to do was this. People will not have the luxury of coming to the bank. If they won't have the luxury of coming to the bank, then why don't you go to them? So what we did was that you go to them, they have mobile phones. So whatever money you have, you give me the money, I give you a voucher. And when I give you a voucher, you scratch the PIN code, you put it in, boom, your money is in the bank.
I see. From their
Yes.
phone to their account.
From phone to their account. Eventually, because they were giving us more than one CD, we changed the name from CDP to speed banking. And that's where, again, my pain comes from what the current guy on the street is going to do. Who is going to look at him to give him 500, 200, 2,000? It is a very painful thing. When I walk through the market today, because I have base clients, I go to Kaneshi, then they know me. I go to Okanshi, because they are my people. And they are complaining. Now they don't want to give us any money. We are not getting, all the microfinances had collapsed. They've lost their money and all kinds of things. Now the problem that I ask, the question that I ask.
That was the then very confident ATO ESSIEN, founder of Capital Bank, today is languishing 15 years in jail. We earlier on had an interview with ALFRED Tuah-YEBOAH, who is a Deputy Attorney General, who explained the matter further and where we stand now. The final thing is that we have 53 million outstanding. If ATO can arrange from jail and have it paid, he may, you never know, have his sentence reduced. But if he's not able to pay, and maybe what the assets that will be liquidated, if it doesn't amount to that money, that's 53 million Ghana cedis, then Ghana loses. But of course, some have been retrieved. So that's good news for us. So Alfred is explaining that to us as well. My name is Ania Frampo. This has been Good Afternoon, Ghana. We'll come again next week, but follow us as we bring you a repeat of it over the weekend. Thanks, and thank you to the production team.